Good morning. May it please the Court, my name is Anthony Russo. I represent AIG Centennial Insurance Company. With me is Mr. David Krug, my partner, also represents AIG. I would like to reserve 5 minutes, Your Honor. The issue that we bring before the Court today is this. Was it error for this trial court to abate rather than to dismiss without prejudice the unaccrued bad faith claim when that pleading destroyed, or at least impaired, my client's right to remove the bad faith count and adjudicate it in federal court when it eventually becomes ripe? The specific errors are two. Number one, before trial, the trial court allowed over our objection an amendment of a UM complaint.
I have a question about that because this case was litigated for about 4 years or so. There was a demand, then a civil remedy notice, and then there was a tender, and it wasn't in accordance with the demand. And then there was a tender outside 60 days, and then it was litigated for about 4 years. And then about 2 months prior to trial, the plaintiff moved to amend to add bad faith.
I think that's accurate, Your Honor. It's a 2008 case.
I reviewed the record. I don't see an objection on the record. And the cases that you cite, there's either an objection on the record, there's opposition to the motion to amend, or there's a motion to dismiss once it is amended, or it's taken up on cert. The only reference to an objection that I see is when Judge Silver, and this is post-trial because the motion to amend went through, it was granted, AIG filed an answer and defenses and tried the UM case.
Yes.
The only time I see reference to an objection is post-trial in front of Judge Silver, who's trying to rack his brain to remember what occurred. And nor can Mr. Werman remember, so he does not even clear that he put an objection on the record. And then I have a question as to an objection, whether an objection on the record is the preservation of the issue. So
yes,
how's this issue preserved?
The issue is preserved. First, the proceedings you're speaking of, Your Honor, the November 25th proceedings before Judge Silver, the judge did recall that the motion for leave to amend was granted over his objection. That's at page 17 of that transcript.
Well, that's after he questioned the viability of an objection or the validity of an objection. He goes, I don't know what that means procedurally.
Is it a motion to dismiss?
Right.
Right. For purposes of this argument, I denied it or overruled the objection, which is in effect a denial of it. So he's recalling his ruling.
But we don't know the basis of the objection in terms of, my question is this, and hopefully I'll make it clear.
Yes, sir.
Was the issue that you're presenting today presented to Judge Silver at the time he heard the motion to amend?
We don't know. We do know it was presented after the trial, before entry of the final judgment, when Judge Silver still had jurisdiction to reconsider any of his pretrial, any of his rulings at that point.
Okay.
And that's our argument. It was properly presented and fully presented in a motion for reconsideration, or to dismiss, or for judgment on the pleadings. So it was at post-trial, before entry of the judgment, that this motion was fully fleshed out with Judge Silver. Judge Silver ruled that he would not dismiss without prejudice the bad faith claim. Those rulings together mean that the bad faith claim is a part of this UM case, and it becomes unremovable, which is the harm to my client, because my client seeks to adjudicate or to litigate the bad faith case in federal court, and it cannot do so now. And the reason for that is under 28 U.S. Code 1446, subsection C, a case, if it is to be removed, must be removed within 1 year of commencement. And the bad faith claim, even though it doesn't exist to this day, and even though it's abated, is deemed to be a part of the UM case, and so it relates back to that 2008 filing date, Your Honor. So we cannot remove it. We have lost our right to remove. by that amendment. Those rulings were erroneous for a few reasons. Number one is that it's an abuse of the amendment privilege under Kimball versus Publix Supermarket from this court a few years back. Amendment is not permitted if it's been abused or if it would prejudice the non-moving party. Here, the only justification for amendment was to deny my client the right to remove, and that's in the record. Counsel was candid about that and conceded that's the reason it was being, the motion to amend was made, and that's at page 17 of that same hearing transcript.
Yeah, but wasn't that motion to amend made when there is legal precedent from the Supreme Court saying that first party action or for UM simultaneously filed with a bad faith action, the court has the discretion to either abate or dismiss without prejudice? Wasn't that the law at the time? Still is.
You're speaking of the Allstate versus Ruiz case?
I am, which came out after Vest.
Yes, and that case was never discussed. That rule, which is the usual typical rule, abate or dismissal, is at the discretion of the trial court.
Well, Vest never addressed abatement either. Vest was whether it was dismissal or summary judgment. The Supreme Court said it's improper to summary judgment,
Yes.
but it's proper to dismiss without prejudice. But the Supreme Court didn't even consider abatement in Vest, but they did in Ruiz 5 years later.
But they didn't consider abatement in either of those cases in the context of the loss of a right to remove. That's new territory. Those cases do not control neither Vest nor Ruiz nor Tranchese, Studio Imports Limited versus Landmark Insurance Company, not this court's decision in O'Hearn versus State Farm.
Yeah, but O'Hearn says if the bad faith claim is premature, the account should be either dismissed or abated. It's clear.
Yes, and did not consider that in the context of an objection based on the loss of a right to remove. None of those cases did, and misapplication of those cases is one of the basis of error of the trial court's decision here. They have misapplied all of those cases. None of those cases apply when the right to remove is at stake. Nobody has written on that. None of those courts, and this court should not allow, I urge it not to be led into error thinking they control.
Well, the fourth DCA has said that loss of the right of removal may be a basis for cert. It said not automatically.
Well, in 4 cases.
And you didn't move for cert in this case.
No, we've been correct. We did not. We're on plenary appeal. There's no loss.
That's because of procedural. If you could have maybe filed a cert at the time of the amendment.
Yes.
But at this point, you are on final judgment, on partial final judgment, which brings up everything that occurred before.
Yes, sir. And then a case called Ludwig versus Liberty Mutual. The insurer did try a certiorari that ultimately failed in this court. This is on plenary review. But to answer your question, Judge Sleet, there are 4 cases from the 4th District, and Geico versus Harvey, Beasley versus Banerjee, Safeco versus Bear, Summer Mills. Those 4 cases, all cert cases, found on the jurisdictional prong that the loss of the right to remove was irreparable injury. They all differed. They had slightly different legal errors in whether or not they reached that high point.
Departure from the essential requirements of law.
Right.
But the irreparable injury prong was satisfied by losing the right to remove.
Well, Harvey was not a case where the plaintiff moved to amend a bad faith action. Plus, Geico and Harvey filed a motion to dismiss or to sever. They responded with something in the record, and I'll point out another part of the transcript where Judge Silver says when the motion to amend was filed and he heard it, he said, I inquired of counsel, and I think he's referring to Mr. Werman. I said, you have a bad faith count on the complaint, and it was addressed. Judge, we can do that. We can just abate it, and we're not obviously going to trial on that. So there appeared to be an agreement between Mr. Brennan and Mr. Werman that we're not privy to by virtue of no record here. But going back to preservation, how was this preserved before the judge?
And I must repeat that the trial court retained its ability to revisit that on a different motion, on a different day, and was not bound by his prior ruling.
But, if that's the case, and certainly I agree with you, the judge was not bound by that, but now aren't we, instead of examining the correctness of the decision whether to allow the amendment, now we're questioning the discretion whether to revisit a prior non-final ruling? It gives you kind of a whole different standard of review, though, doesn't it?
Well, the judge made his findings specific, Judge Silver did, for instance, and he said, I'm basing, in part at least, my decision on judicial economy, citing to the Tranchese case. That's misapplication of the law. That's a legal error that I think this court can review de novo, and must review de novo. The judicial economy argument is false. I don't mean that in a pejorative sense, but is incorrect, and I'd like to address it. My opponent argues that we want to remove the case simply to get the second bite at the damages apple in federal court. Their argument is based on the assumption that the federal court will not apply this verdict as the measure of damages in that bad faith case. They want to keep their bad faith case in state court based on the assumption that the state court will apply the verdict as the measure of damages. But there is only one law, and it controls in both forums.
Mr. Russo, you're coming down to about 5 minutes, so you can do with them what you wish.
Okay. That judicial economy argument is false for that reason, and it is irrelevant because this court does not need to determine what the measure of damages is in the bad faith case. That decision will be made by the judge who handles the bad faith count. What we're asking the court to do is to reverse the judgment, that part of the judgment, partial final judgment, that reserves jurisdiction to handle the bad faith case, and to hold that a trial court does err when it refuses to dismiss without prejudice the bad faith claim that has not accrued when the insurer says, I'm losing my right to remove. That right should be respected. That action would preserve all the parties' rights. It would preserve their right to bring the action and our right to have that action litigated in federal court.
Thank you.
Good morning. May it please the court. My name is Joel Eaton. I represent Maryland Brace. You all have had a long morning. I'm going to try and be brief. My argument on the preservation issue is in the brief, and I will refer the court to the brief. Mr. Russo has been very low-key with the court. I was prepared to stand up here and say, it's not fair for him to call what we did an abuse. It was not abusive. It was thoroughly sanctioned. The 4th District had decided several decisions that were squarely on point. The 1st District has rejected Mr. Russo's position in a case squarely on point. The trial judge really had no choice, given those district court decisions, but to allow this amendment and to abate it. Now, there are 2 other cases which I've relied on here, one of which has already been mentioned, and that's the Supreme Court's decision in Ruiz. It arises in a different procedural context, but the language is certainly suggestive of the propriety of what happened below. And that language is, we caution that where coverage and bad faith actions are initiated simultaneously, the court should employ existing tools such as the abatement of actions to ensure full and fair discovery. There is a decision out of this court. Judge Volante wrote the opinion. It's the State Farm versus O'Hearn. And it, as Judge Sleet observed, says, when a plaintiff does not and cannot allege that there has been a final determination of both liability and the amount of damages, the plaintiff's bad faith claim is premature and should be either dismissed without prejudice or abated. Now, this arose in a different procedural context than the procedural context in which we are involved here. But at the time the trial judge ruled below, he was pretty much compelled to do exactly what he did. And there are at least 3 good reasons for the rule that you are allowed to join a first-party UM claim with a first-party bad faith claim. It's the same defendant, same insurance company in both counts. The damages are the same in both counts. Once you prove your total damages in the UM claim, you have established your damages, or so we thought, and I'll get to that point in a minute, in the bad faith case. But the real motivating, driving factor here is that some of the federal district court judges in this state have ruled. When you try a UM claim and you get your damages established, in this case it was $1.3 million, I believe, and a $25,000 policy, the federal courts are not going to give any res judicata or collateral estoppel effect to the damage finding in the UM claim. Your plaintiff, you're going to have to reprove, retry your damage claims in the federal court. Now that gives an insurance company 2 bites at the apple. Here's the scenario that's set up, and here's what plaintiffs are afraid of, and here's why the amendment was requested in this case. If the UM claim goes to trial and the insurance company is satisfied with the damage judgment because it's lower than what it thought it was going to get hit with, it doesn't remove. It allows the bad faith case to go forward in the state court, and the plaintiff is stuck with the low assessment by the jury. But if the insurance company says, oh my God, this is much bigger verdict than we thought we were going to hit with, we think we can do better over in federal court, we're now going to remove it and hope we get Judge Rice-Camp or Judge Moore, who have ruled that the plaintiff's got to retry the damages, and we're going to get a second bite at the damage apple, and hopefully the damages will be less than what the state court jury decided. That's the problem. One of these days, the 11th Circuit is going to straighten out these Florida U.S. district courts, and we're going to get some uniformity where this court can make a reasonable and logical judgment about how to mesh the notion of these 2 claims, abating one with the removal rights of the defendants and so forth and so on. Right now, if you were to accept Mr. Russo's argument, the plaintiff's going to may have to, not if he gets a different judge over there, but may have to retry the damages, and the insurance company's only going to be liable for the damage award in the federal courts, not in the state court. There are the 2 most important decisions came out after I wrote my answer brief. I sent them up here in a notice of supplemental authority. I don't know if the court pulls these things out of the file, but I would urge you to read Geico versus Payton, P-A-T-O-N, Judge Gross's opinion out of the 4th District, in which he discusses the point I just made about the 2 bites at the apple. This case arose in the context of a 2-count complaint in the state court for first-party UM claim, first-party bad faith, in which the insurance company who litigated the damages in the first case took the position that it could relitigate the damages in the second case. The 4th District rejected that. And in some language that looks like it came out of my brief, and it was not, because I was not involved in this case, Judge Gross wrote, forcing retrial of a plaintiff's damages at a first-party bad faith trial, as Geico urges, is such bad policy that we do not glean even a hint of its existence in any case the Supreme Court has decided in this area. Under Blanchard, the recovery of damages in the first-party action is necessary for the accrual of the bad faith claim. Geico participated fully at the first trial with an opportunity to challenge the plaintiff's evidence and a powerful motive to suppress the amount of damages. When it comes to a judge or jury's factual determination of damages Florida's policy is not to give multiple bites at the same apple, absent some legal infirmity in the first trial. That's basically the argument that I just made to the court. The second decision that's part of this notice of supplemental authority, Safeco Insurance Company versus Bear, in an opinion written by Judge Martha Warner, it does arise in the precise context presented here and addresses, in a cert petition case, the fact that allowing joinder of these two claims in one state court lawsuit deprives the defendant of its removal rights. It says, yes, it's an irreparable injury, therefore we can take cert. But we do not find a departure from the essential requirements of the law, because there is a long line of Fourth District cases, beginning with the Trancasi decision, which says that it's perfectly permissible to allow the joinder of these two claims and abate the bad faith claim until the claim has been decided. Mr. Russo relies on third-party bad faith actions. There's some cases, one out of this court, that doesn't permit the joinder of a third-party bad faith claim with the suit against the tortfeasor. But the reason for that is different than first party. A first party claim is against AIG. A first party bad faith claim is against AIG. AIG gets its day in court in the first suit on the damages issue. It has no due process complaint because it was a party to both lawsuits. Not so in a third-party situation. Because of the non-joinder statute, you can't bring in the liability insurer. So in theory, at least, although they're footing the bill and providing the attorneys, because they were not a party in the underlying suit against the tortfeasor, they have a due process challenge to joinder in that lawsuit, and the plaintiff arguing that the damages have been determined. So the third-party bad faith cases simply don't apply here. And I promised you I would be brief.
You still have a little time to be brief.
Pardon me?
I said you still have a little time to be brief, Mr. Eden. But it's running out.
I'm worn out just listening to three of your cases this morning. Frankly, I think AIG protests too much. You know, they write an insurance policy to a risk located in Florida. They are doing business in Florida by any measure of what that term means. They defend their insureds in state courts all the time. They should not be so anxious, it seems to me, to rush over to federal court to defend the bad faith claim. And I think that what is at issue here is the problem of the federal judges that require the plaintiff to retry the damages. The two bites at the apple scenario that I have discussed. Judge Warner's opinion in the Bear case makes my argument better than I can. I commend it to the court as a proper resolution of the legal issue before the court, and I thank you for your time.
Thank you, Mr. Eden. Mr. Russo, you have right about 4 minutes.
Thank you, sir. We cited to the Payton versus Geico case in our reply brief. If Payton is the law, if it's the law, then we should prevail because there'll be no second trial on damages. There'll be no second bite at the apple. I don't think my opponent is saying that Payton is not the law because his second bite at the argument, apple, rests on the presumption Payton is wrong, doesn't apply, or is not the law. There's only one law as to whether the verdict is used as a measure of damages in the bad faith case. This is a diversity case. State law controls. It will apply in state court. It will apply in federal court. That's our first response. Second, this isn't an issue for this court. This court is looking at a partial final judgment on a case, not looking at the decisions made in a bad faith case. The judge in the bad faith case will apply the law, whatever it is, and make a decision as to what the measure of damages will be. And at some point in the future, in this case perhaps, there will be an appeal where the measure of damages becomes an appellate issue. It's not an issue here. The issue here is whether or not we were deprived of a right to remove, a statutory legal right. That should be enforced by the court. There was you didn't hear any justification for the amendment that was made except to deprive AIG of its right to litigate that bad faith case in federal court. That's an abuse of discretion. It prejudiced my client. Under Kimball versus Publix, it should be reversed. They misapplied Tranchese. Judge Silver respectfully did. Studio Imports, the O'Hearn case, Ruiz, none of those cases considered the insurer's right to remove in the context of those discovery cases. I guarantee you, none of those cases looked at the right to remove as an element that figured into the consideration of the court's decision. We urged the court to look at the Harvey, the Beasley case, the Bear case, and the Sunrise Mills case, all from the 4th District, which said this loss of this right is irreparable injury. That much we hope that the court would memorialize in an opinion for use. We would ask the court to disregard the first third-party distinction that's raised in the cases because it's irrelevant. When we lose our right to remove, it doesn't matter if we're in a first-party case like UM, in a third-party case, or if we were a commercial defendant, or if we were in a citizen versus citizen dispute. When the non-resident defendant loses its right to remove, it's irreparable injury, and it doesn't matter if it's first or third party. Based on that misapplication of law by the trial judge, we ask you to review the case de novo and reverse the judgment.
Thank you both.
Thank you.
Thank you.